Assalamualaikum. The people that involved in this case is Kenko Incorporated. Kenko Incorporated is a medical health company. The second one is Sidman, the independent auditor for Kenko Incorporated. Next, the board of directors that involved in this massive fraud. Lastly, newly hired financial officer. The Kenko management involved in a massive fraud to inflate the value of company inventory, and the case was reported by the newly hired financial officer to the Security and Exchange Commission. The auditor, Sidman, either never discovered or failed to report the fraud. Later then, Sidman was charged for failing to detect fraud made by the management of the company they audited.
Auditor's defense in this case is non-negligent performance. Sidman claims that the audit was performed in accordance with auditing standards, even though there were undiscovered misstatements. The auditor failed to find the fraud, but successfully able to argue that it was not negligence. Principles or concept highlighted from this case is ordinary negligence. The principal issue in Kenko involving alleged negligence is usually the level of care required. The result at the end of the Kenko's case, the auditor successfully argued that the management team's deceitful preventing the auditor from uncovering the fraud. Sidman was found not responsible in this case by the Court of Appeal.
As for the second case study, which is 1163 Tenants Corporation versus Max Rothenberg. The Max Rothenberg is a certified public accountant.
Defendant is Max Rothenberg from CPA firm. Meanwhile, the plaintiff is 1136 Tenants Corporation. 1136 Tenants sued the auditor for failing to detect fraud amount to $235,000 as part of the unaudited financial statement. The auditor never engaged in conducting audit, so the auditor could not detect the fraud that happened in the corporation.
The liability of the auditor is negligence. They failed to uncover the fraud from an audited financial statement, the preparation of worksheet entitled missing invoice, and they need to follow up any potential significance.
Auditor defense that can be used is absence of causal connection. It states clearly that the auditor never engaged in the audit, so fraud cannot be detected. 1136 tenants sue based on fraud in the unaudited financial statement because they know clear what service that auditor provide.
The principles or concept that highlight from the case is importance of engagement letter to clearly establish an understanding with the client regarding the nature of service to be provided by the auditor or accountant.
Tenants don't have a clear engagement about the nature of the service given by the CPA. Engagement letter must be signed by the auditor and the client to clear out about all engagement, especially unaudited engagement and any restriction on the CPA activities.